Dominic says, just clicking through yesterday's highlights.
Is that on a different YouTube page?
I think
there's someone over
Certainly not presented by Labour
the compilation, Christmas, the perfect Christmas gift. Called a real live stream we've loved.
Something for your wife to consider, Alex. The equivalent of the photo book for the year. The video highlights of your court appearances.
Well, my children have never seen me in a week, so it's
right.
really exciting for them.
I have. I've never been forgetting. We had to try to take parents take your clothes you wear to work today when Alexander was in reception, and he was. I've never seen a child more embarrassed. Every single child in the class said, "Put movie on." It's just dying of embarrassment.
I worry about mitts in reception.
Later, there was one case where we knew that it was going to be quite an unusual day, and he was cross-examined by father. He was at the heart of this case, which was a long, 4-month case. So, and the poor chap sort of arrived for his kit, and then looked at the back of the court, and it was just full. I mean, there were 200 people there because we had our secretary, his mother come, Rachel came, and it all proves work.
We're live now, Steve.
Oh yeah, we're live. Yeah. It makes it an unwieldy long document, but it means finally it's covered where it's supposed to be covered.
That's
I've done it
actually
in different ways.
because I don't go back to this kind of thing.
Yeah.
I just never really and I've had a I can see that's a very good way of incorporating.
Yeah.
Too late, possibly.
You might have 20 minutes. I think it's crucial to be involved in this kind of democracy.
You
Yeah.
Yes.
Yeah. That's what.
Yeah.
You know, I mean, it's
Yeah.
him when I was really about to answer. Don't you want to ask Mr. Anton what he thinks? Grabbing both, it goes, I know what he thinks.
Nice.
But you know, I mean, absolutely off the
Yeah.
head.
But that's kind of old-fashioned, isn't it?
Yeah.
You wouldn't catch baby panic.
No.
This kind of stuff.
Any page 8 was blank so far if you want to. Luckily, he don't tell me.
All rise. Appeal offered in the matter of Hewes and West Hertfordshire Acute Hospitals, NHS Trust and others.
Yes, Mr. Smith.
Good morning, my name's Malay. My Lord, I'm, I hope, going to be quite swift in
Good.
just highlighting
Yes,
several
thank you.
points at the end of my skeleton argument. My Lord's page 21, paragraph 53 of my skeleton. The submission is that the judge failed to undertake the evaluative exercise recommended by Mr. Justice Green in C in North Cumbria in relation to Mr. Crocker. You have the submissions there within that paragraph, my Lord, and I'm not going to repeat them here. Over the page, my Lord, paragraph 56, it remains the appellant's position that there are two significant procedural issues. First, that it was not open to the judge to find the examinations of Doctors Roffey, Kirkby or Mackenzie to be unreliable because it was not the defendant's pleaded cases that those measurements were unreliable. And moreover, they were admitted by the first defendant in the defence. And just stopping there for a moment, my Lord, pleadings do still matter. They set parameters for trial, and those are the parameters which set out parties' respective cases. Secondly, my Lord, Mr. Cowie's evidence that bladder, autonomic and pain nerve fibres are smaller and more susceptible to compression than larger touch and motor fibres to explain why the claimant had loss of bladder function but maintained anal tone and perianal sensation was entirely safe. There is no evidence to support that. My Lord, in relation to paragraph 57, I don't repeat all of it, highlight the following, little Roman 3, towards the foot of page 22. Just the principle here is that the appellant's submission has always been that painless urinary retention and loss of the ability to void could just as equally equate to a concussed nerve as much as a severed nerve. And I'll come to the evidence on the point in a moment from Mr. Mannion. But what the literature confirms, and of course the judge found the literature to be of limited utility, what the literature confirms is that the prognosis is poor after the point of overflow incontinence. The majority of patients who reach a bladder volume capable of overflow incontinence will have suffered death of all or most of their autonomic bladder nerve fibres, hence the poor prognosis. And my Lord, it may briefly be worth going to those two references. I'm sorry that you haven't got specific page references at Supplemental Bundle 1, tab 25, first of all. This is the first Gleaven-McFarlane paper from 1990.
Yes.
And it's page 275 in terms of the methods. And your Lordship will remember this was the case where they reported that full bladder control was claimed ultimately by 26 of the 33 patients, 78.8%. In terms of the inclusion criteria, if one looks at page 275, left-hand column, first full paragraph, 7 lines down, only patients completely unable to void or who had bladder enlargement with dribbling incontinence were included. And so inability to void was a criterion for inclusion in this study. That's the first reference, my lord. The second reference is within the next tab, tab 26, the second Gleaven-Macfarlane paper, and in particular, on page 279, the right-hand column, first full paragraph, nerve fibres have differing susceptibilities both to ischemia and mechanical trauma, and then describing the small fibres much less resilient than the large fibres, and then this reversibility is dependent on relief of both the mechanical pressure, which is obstructing axoplasmic flow, and the resolution of ischemia/venous congestion. Then over the page, my lord, 280, left-hand column, 3 lines down. Secondly, conduction in a single nerve fibre is an all or none phenomenon. Thus, an incomplete lesion of a nerve root does not mean that the individual nerve roots are partly affected, but that some of the fibres of the root are affected and others not. Thirdly, the distinction between an incomplete and a complete lesion of the cauda equina is extremely important. Studies of major sacral resections for tumour indicate that complete unilateral loss of the sacral nerves is consistent with near normal pelvic autonomic function. Partial loss of cauda equina function therefore may cause little or no disability. My lord, the literature, put shortly, does not establish that prognosis is poor. There is only painless urinary retention without overflow incontinence. Some patients in this group will have sufficient nerve fibres that survive to enable some recovery. My lord, it may be helpful just to go to Mr. Cowie's evidence about this in the joint statement of the neurosurgeons, a supplemental bundle, charcoal bundle, tab 24, page 265. At the top of 265, second line, Mr. Cowie says that if decompression can be carried out after onset of retention due to loss of nerve impulse transmission along the nerve fibres controlling bladder function, but before nerve cell death from ischemia has occurred, there is a prospect of better outcome for the patient. So that's the distinction that Mr. Cowie draws there. Of course, my lord, some patients with urinary retention and overflow incontinence recover, and that wasn't really dealt with adequately by the judge in her judgment. And the recovery of even some patients with painless urinary retention and overflow incontinence suggests that these features are not determinative of permanent bladder function loss.
I thought it was agreed that the basis on which the judge was to proceed was that once you were in CESR, the probability was it was too late.
Correct, my lord.
So why is it relevant that, as I think everybody accepts, some people in CESR can recover?
Indeed.
Because the question for the judge was Mr. Hewes in CESR or not?
Indeed. My lord, I think it relates to the judge's conclusion in paragraph 91.6 of her judgment. Seemingly equating nerve death within 6 hours with loss of executive control of bladder at 12:03. And put simply, we say that is wrong.
I see. Can I ask you something else?
Of course, my lord.
One of the first things you said this morning was your paragraph 56. Mr. Cowie's evidence that bladder autonomic and pain fibres are smaller,
yes,
and more susceptible to compression than larger touch and motor fibres was entirely theoretical. But you read us a passage from Gleave and Macfarlane which seemed to say just that. Have I misunderstood that? That's at page 279 in tab 26. The small, I don't know what my I can't even pronounce it, what that means, but the small fibres that subserve pain sensation are much less resilient to compression than the larger fibres concerned with motor power. Is that not a...
Well, it's a relevant point, but if one just looks at that point for a moment, my lord, it may may be quite close to what Mr. Cowie was saying, but if the small fibres subserve pain sensation and parasympathetic function, and they are less resilient, one would not then expect the findings on digital rectal examination that came at 9:20, 10:50 and 1500, because clearly there was sensation. Power point may relate more to the bladder.
I thought what you say in paragraph 56 is that Mr. Cowie's evidence about larger touch and motor fibres explained how you could maintain anal tone but lose bladder function. And, have I not understood?
No, my lord, I think your lordship's understanding is correct, and possibly a point in paragraph 56 in relation to
Thank
Mr.
you.
Cowie. My lord, if we might just go to the top of page 82, 23 internally in my skeleton, and it's the reference to Mr. Cowie's report at the very top of the page, the Roman 4. So it's charcoal bundle, tab 20. It's page 217. And paragraph 4.5 at the foot of that page, Mr. Cowie says this: we appreciate that once a patient loses the ability to evacuate the bladder, it does not necessarily mean that irretrievable damage to the nerves controlling bladder function has occurred, whereas continued compression of the non-functioning nerve will lead to cell death and no prospect of recovery. If surgery can be carried out before this final step in the pathophysiology of nerve compression, there is a prospect of subsequent electrical recovery for at least some of the non-functioning nerves. It is difficult, therefore, to know exactly when a non-functioning bladder becomes irretrievably damaged. And my lord, we pray that in aid of our position, in effect, that the judge has been too concrete in relation to the nerve death theory. My lord, Little Roman 5 on page 23, you already have my point that the judge concentrated on the bladder, didn't address the issue of whether the claimant's bowel function might have been better with earlier surgery. And my lord, paragraph 58 speaks for itself. Just below the middle of that paragraph, the submission that if the judge is correct, no patient with painless urinary retention with or without overflow incontinence could ever recover any function remains the appellant's submission. My lord, on the concussion point, which I flagged a moment ago, we turn over the page to page 24 and Little Roman 3. This was in the course. First of all, if we go to tab 26 of the charcoal bundle, we've looked at 279, 280, the Gleave and McFarlane point, and the different types of nerve fibres. But Mr. Mannion was asked about this in his evidence, and it's the light grey bundle, tab 12, my lord. It's page 326. At D to F. And in particular, starting just below D, just because a patient has loss of neural function doesn't equate to cell death. And then giving the example of waking up with a dead arm, where the arm is numb and feels paralyzed, remains so for a minute or two until we throw it around, shake it, restore some blood flow. So essentially, all of us have suffered a compressive ischemic neuropathy that manifests as a complete sensory and motor block, but it doesn't mean the cells have died. Of course not, that would be ridiculous. So just because a patient presents with numbness or with motor function, all it means there is a conduction block, for whatever reason, electricity is not getting along that nerve to the target, whether that be in the skin or in a muscle or in a bladder. So in terms of the position of the bladder at 1203, our submission is that bladder scan is as consistent with a concussed nerve fibre as it could be consistent with a nerve fibre that's more seriously damaged.
Were these transcripts obtained for the purposes of this appeal? Were they being obtained during the course of the trial?
You give me one moment, my lord. Just the appeal, my lord.
Just the appeal.
And my lord, Little Roman 5 on page 24 refers to the animal experiments which the 6-hour nerve fibre death theory is based on. Simply put, that's, of course, it wouldn't be ethical to perform such experiments in humans. It's possibly questionably ethical to perform them in animals now. But in any event, the position, if one accepts the examinations performed by Dr. Kirkby at 9:20 and 11:20, the claimant could not have had complete compression at those times or at 1500 because of Mr. Mackenzie's finding of some perianal sensation.
So if I could just come back to what you say in paragraph 58 of your skeleton.
Of course, my lord. 58 or 56, my lord?
58 on page 20.
Beg your pardon, yes.
You draw attention to your submission. If the judge is correct, no patient with painless urinary retention with or without overflow incontinence could ever recover any function. Which bit of the judge's judgment are you relying on for drawing that conclusion?
My lord, it's in terms of it's really all of paragraph 91, my lord. But the weight that was placed by the judge on the bladder scan at 1203 as determining that the claimant was in CESR on that point was, we say, not a finding that was open to her or ought to have been made. And my lord, perhaps to highlight the point, in terms of the pleadings, the particulars of claim referred to the bladder scan being performed at 1203 and 621 mils of urine, and the claimant being unable to void after that, after he'd been requested to. That was simply admitted in the defences, no reference made to it, no reliance placed on it in the defences in terms of causation. So it seemed very much until the joint statement of the neurosurgical experts a month before trial to be a non-issue. And hence the importance, again, I come back to the pleadings point, that it really is important that the court determines the case on the pleadings. And the defendant's position on causation moved very, very substantially.
So my query remains is, and the way the judge has expressed herself, she's not purporting to make a generalised finding of the kind which you attribute to her. You are attributing to her, in effect, a finding that no patient with painless urinary retention, with or without flow, could ever recover any function. Does she anywhere say that? Isn't she dealing with this particular case?
She is dealing with this particular case, my lord, clearly. It's really in 91.6, my lord. And the implication appears to be there that there has been progression to nerve death within 6 hours here by 1203.
But then all experts agree that success can progress.
Indeed.
Again, it's quite cautious.
We say, again, that's an error that Mr. Mannion didn't agree
No.
with that. And it's page 280 of his evidence. But in terms of the start of that paragraph and the end of that paragraph, we say there is a strongly implied link between the two, and the judge has made a leap which was not open to her.
Okay. Yeah.
My lord, I was on Little Roman 5 in paragraph 59, and I think the points have been made there. At the foot of that page, little Roman 7, of course, the first defendant admitted the presence of anal tone at the time of Dr. Kirkby's examination, just before 11:20. Not only admitted it, but said that actually it wouldn't have been mandatory to seek an urgent MRI scan on the basis of a finding of some anal tone. And so, if your Lordship needs the reference, it's the blue core bundle. And it's the defence of the first and second defendant, which appears towards the back of that bundle behind tab 19.
First and second defendants, tab 20.
First and second defendants, tab 19, my Lord.
Tab 20 in my bundle.
Oh, I beg your pardon, my Lord. It's, I think, my Lord, it's tab 19 in all of our bundles. I'm just checking. It hasn't been misfiled. Tab 20 is defence.
Which page number?
397, my Lord.
That's fine, thank you.
And it's little d, my Lord, at the top there, what was said. It wouldn't be mandatory or reasonable to interrupt or delay a routine MRI list for a patient presenting with suspected CS, but who has normal anal tone.
Normal.
My Lord, yes.
Yep.
And, my Lord, on the very last page of our skeleton, the top line there, I've already made the submission which starts at the end of that first line, but it remains a sound submission. And, my Lord, for all of those reasons, we submit that the judge's unsound findings on legal causation should not be permitted to stand. Let's assist your Lordship further.
Before I say anything further, could I raise one point with you, Mr. Hewes? It relates to ground 7, which leave to appeal was refused by the single Lord Justice. It might be said that some of your submissions perhaps have in effect traversed some of the points raised in ground 7. But it's the very last line that I just want to raise with you.
My Lord, yes.
Well, why was this said?
My Lord.
And is it said that there was an appearance of bias because the judge found against you on all material matters?
Certainly not, my Lord.
But is this colouring the approach of the claimant? The feeling there was an unfair trial because the judge found against you on everything that mattered?
No, my Lord.
It's a very unfortunate point to raise.
My Lord, I'm afraid that my involvement in this case only came after permission to appeal had been granted and refused respectively, so I'm unable to assist further in relation to that.
But what's been asserted at this stage, and this must have reflected presumably the perception of the claimant's trial team, that there was an appearance of bias because the judge found against the claimant on the points that mattered.
Well,
that just completely misappraises the judicial function.
I wasn't involved in the process at that time.
Well, it is withdrawn, is it? I know actual bias is not being asserted.
No. Well, my Lord, it's...
The judge may be right, the judge may be wrong, but she has to find the facts as she sees them. She may be wrong, you're saying she is wrong. Right, well, I hope not to see a submission of that kind ever again. But I just wanted to... Anyway, I'm just anxious this hasn't been the underpinning
not at all,
in part of this appeal. Just sounds
absolutely, and
good.
It very much.
And it certainly has not been any part of your approach.
Not at all.
I'm sure Mr. McLeish sitting in this court as well. All right.
Thank you, my Lord.
That's very helpful indeed, Mr. Booth. Thank you very much. Yes, Mr. Hutton, you're going next? Or?
My Lord, no, Mr. Anton was going to go next, given that he's first in time in terms of the GP, if that's convenient for everyone.
Well, and also, Mr. Booth did deal D3 first.
Precisely, yes.
I hope that's all right. My intention, my Lord, is to address both grounds 1 and grounds 2, which are specific to the GP, and then to hand back to Mr. Hutton, who will deal with legal
What
causation.
won't assist us is if you simply duplicate your submissions.
Absolutely.
You can simply adopt where you adopt, but otherwise it just becomes...
Absolutely, and that is why I'm going to leave ground 6 entirely to Mr. Hutton, the legal causation.
Do you have every faith in him to do it right?
I have every faith at the moment.
All right, Mr. Anton.
My Lord, could I just start by saying that we recognise on this side of the court the injuries that have been suffered by Mr. Hewes,
Yes.
and to note that whatever I say about his case and his appeal, it's not intended that should belittle his injuries.
No, well, as I said, the judge paid
He did.
tribute to him, and this court would endorse that.
And my Lord, these submissions reflect and obviously explain what's already in our skeleton argument, but it's not my intention to go through every part of that skeleton, not least in the light of the narrowing of issues.
None of you are deemed to waive points you haven't specifically raised already. Yes.
Well, my Lord, can I turn then straight away to breach of duty? Mr. Booth, my learned friend, indicated that this was a simple point. And can I identify, or at least attempt to identify, that simplicity before we get too far into the papers? Suspected cauda equina syndrome requires an urgent investigation by MRI. An MRI investigation can be undertaken either in accident emergency or by orthopaedics. If confirmed, it then needs to be treated by a specialist orthopaedic surgeon, one who specialises in spinal surgery, or a neurosurgeon, and they decompress the material nerves. Whether accident and emergency or orthopaedics in a particular case might get the MRI investigation done more quickly depends on a number of common sense factors. Who's available in each department, the patient demands at that time, and any other specific resource and facility matters at that particular moment. Put another way, sending in any particular case to A&E may be quicker or may be slower than contacting orthopaedics. And so it's not surprising, my lords, there are two documents which reflect these observations precisely. And can I turn to those straight away? And the first is in the charcoal bundle, supplemental 1, at tab 30.
Tab
30.
30. 30.
This is a 2009 document, so predates the events of this case. It's produced by the Society of British Neurological Surgeons, and it deals with...
And the date is?
October 2009.
October 2009,
at the bottom left-hand corner. And what one sees under imaging, so halfway down the page, MRI scanning is the preferred imaging modality and should be performed without delay to establish the cause of symptoms. And then there's a section, standard of care. All cases of suspected CES should be referred to and assessed at the local emergency department or orthopaedic neurosurgical service, depending on local facilities and arrangements. And if one then drops down to the fourth bullet point, beginning if cauda equina compression is confirmed by MRI scan. So the MRI has taken place, there's been a positive outcome. The local neurosurgical or orthopaedic spine unit must be informed immediately, and the images made available, next paragraph, patients should be transferred directly to this unit with appropriate documentation and images, and then decompressant surgery. So that envisages the alternative approaches of getting the MRI done. And of course, if there is confirmation of CES, then you need to get the surgeon involved. And that's reflected if we go to the document my learned friend took you to yesterday at tab 36. So this, I think the parties agree, is that it postdates events, 2015,
16, yes.
16. And my learned friend took you to the paragraph imaging and read it out, but didn't complete the final sentence. He got as far as, in the penultimate line, receiving the patient. So MRI scanning should be undertaken urgently at the hospital receiving the patient in order to ensure timely diagnosis and when appropriate, immediate referral and transfer to a spinal unit. And then again, if one looks at little 1 underneath that, cauda equina compression confirmed, this should precipitate an urgent referral to the appropriate surgical service. So, my lord, against that background, in that nutshell, it's very difficult to see how a general practitioner, having not been issued with a crystal ball, could be considered to be in breach of duty, bolum or belitho, to refer to A&E, which might in a particular case prove quicker or slower. And it becomes from the third defendant's perspective to see how it could be said that no judge could reasonably have found that a GP was not in breach of duty on this point. And it has never been part of the third defendant's case to say that it would have been wrong to try and contact orthopaedics. But it was not wrong to send Mr. Hewes to A&E. My lord, I want to turn to say something about the nature of the appeal before I turn to the specific grounds. I just want to introduce the sea of evidence relevant to this ground alone. I'm going to do that without turning to any documents, just to make those comments on the nature of the appeal. So to state what is, I'm afraid, obvious, all the lay witnesses produced statements. All the relevant witnesses on this issue gave oral evidence and were cross-examined. And all the expert witnesses produced reports, then joint statements from like disciplines, and in addition there were some supplemental reports as well. And the evidence that was heard by the judge falls into a number of categories. The first was called the GP category. First, Dr. Tanner himself gave evidence, he explained what he did, and he rejected any suggestion of incompetence. Then there was expert evidence from the GPs. First, Dr. Swales on behalf of the claimant. He was and remained critical of Dr. Tanner throughout his evidence. He considered that a competent GP could have referred to A&E and that it was illogical not to do so. No part of his evidence, as we will see, rested on the claimant's status as a follow-up patient or his previous medical history. His experience was that a referral from a general practitioner to orthopaedics by telephone was easy, and he considered that that could be achieved in generally less than 2 minutes at 6:15 in the morning on the basis that doctors wouldn't really be doing anything at that time of the morning. And his experience was based on referral by him of 2 patients in these circumstances. Then there was Dr. Russell on behalf of the third defendant, who was supportive of Dr. Tanner. He considered that there were several options open to Dr. Tanner, and was to act in the way and did. Evidence to the court was that, in contrast to Dr. Swales, he had experience of considerable difficulty of getting hold of an orthopaedic doctor to arrange a referral. His experience was it tended to introduce delay, and in his experience, he'd been passed from pillar to post and then just patient to A&E anyway. And his experience was the same as colleagues to whom he had spoken. Then, my lord, the judge heard on this point. And this is relevant because it's looking at the other end of the telescope, if I can put it that way. In other words, for there to be a system of referral, one's got to have an orthopaedic department prepared to accept and deal with it. So the two go together. So the first evidence that was heard was lay from Mr. Langdon, and we covered much of that yesterday, and he explained the policy at Watford was for orthopaedics not to accept someone like Mr. Hewes who hadn't been examined by a doctor, and he confirmed that remained the policy and indeed had been endorsed by his local commissioning body shortly before the trial. And then there was expert evidence. We saw a passage from Professor Fairbank. He's the professor of spinal surgery at Oxford and a practicing consultant. And he said that it was standard practice for GPs, and your ladyship was taken to that answer, where he said standard practice for GPs to send to A&E. And from his perspective, he also would send a patient to A&E. Then there was Mr. Thorpe, who was called on behalf of the claimant, orthopaedic expert. And he started by saying in his evidence, in his written evidence, that no orthopaedic department should reject a patient who has been referred in these circumstances. And then in circumstances which I will turn to in dealing with grounds 1A, he changed his evidence to be that it was fine to send a patient to A&E unless they had previously been treated by that orthopaedic department. So the follow-up issue arose. And that was a change in his evidence. Then Hewes had some literature and guidance to look at. And we've seen some this morning, and your Lordship saw some yesterday. There was no formal guidance for GPs on the management of CES and the pathway by which suspected CS should be dealt with. And we say all that literature actually supports Dr. Tanner. There is clearly a dispute on that. And one, and only one, of those several documents are the NICE guidelines on which the claimant now appears to rest his case. And that document has had a lot of airtime. It provides guidance on identifying and acting on red flags for suspected CES when treating sciatica. So we'll have to look at that document in some detail in response to the grounds. But that was the breadth of evidence on this single issue. And the way the judge...
Can I ask, I'm sorry,
of course, my lord.
Excuse my ignorance.
No.
What is sciatica, and did Mr. Hewes suffer from it?
He did, and what I might do... Well, sciatica is compression of a nerve, which has an impact in the back, has an impact often giving pain down the leg, essentially. So you get referred pain because there's a compression in the back of a nerve, goes down the leg. But what I can do, my lord, is when we go to the NICE guidance, there's a very nice summary of it. Perhaps I should turn it up straight away. Thank you very much. Tab 33 in the charcoal bundle, my lord. And page 311. Your Lordship's question is, what is it? And you'll find that halfway down the page.
Thank you.
Was there any evidence, can you remind me, that in cases of suspected cauda equina, which are referred to A&E, that the A&E might send off an MRI scan directly without referring up to an orthopaedic department?
There is, my lord, and there's quite a lot of evidence on that, both from the witnesses and elsewhere. But in fact, in this case, that's what happened. The MRI was organised.
Yes, but the question is what a GP could reasonably be expected to know and understand. Because as far as the GP is concerned, he may not necessarily think if you go to A&E, you'll only then end up by going to orthopaedics. He might think, and if you go to A&E, think the GP may well be right. This looks like cauda. I'm going to send you straight off an MRI scan. That may explain why a GP would think A&E is a good place to start.
Well, my lord, this GP knew that A&E had an MRI scanner.
Because he'd been at WGH himself.
Whereas Dr. Swales, and I'll be coming to this later, said that whether or not an A&E department has an MRI scanner is something that's outside his expertise. So when he criticises Dr. Hewes' approach as being illogical, he does it without having any knowledge whatsoever about the facilities at the place to which Dr. Tanner was sending Mr. Hewes.
Yes.
But I was going to turn to what the judge did, if I could put it that way. Obviously, she heard the evidence, but your Lordship will have picked up during the course of looking at some of the transcripts that she asked a number of questions throughout, which, in my submission, without exception, reflected that she understood the issues in the case and understood that there were opposing positions before her. And she heard detailed submissions, both opening, closing, written and oral, from all the parties. And in her judgment, which we will have to turn to, but just in broad terms at this stage, she summarised the key background to the condition. She identified the key documents, including the NICE guidance. In a section headed the law starting at paragraph 31, she identified and set out the correct tests for breach of duty, namely Bolam and Belitho, and she identified the evaluative approach to the assessment of expert evidence, looking at the evidence as a whole and not being distracted by cosmetic blemishes in that evidence. And then from paragraph 41, over 4 pages and 14 paragraphs, she analysed that evidence and considered the position in respect of Dr. Tanner's conduct on this simple point. And we'll have to look in detail at what she says, but it was an extremely thorough examination of all the factors that were in front of her. And we say against that background that the grounds of this appeal seek to revisit the judge's evaluative process and her assessment of the evidence. And this gives rise to 2 problems. The first is, as was part of an exchange between my Lord Justice Nugee and my learned friend yesterday, that the position of the trial judge cannot be recreated by the speedy jumping from one island of evidence to another. But it cannot even be recreated by inviting this court to spend 10 days reading all the materials and transcripts, an invitation that I suspect would not be accepted.
This is a court of review, not a court of rehearing.
And a key feature...
I think Mr. Booth accepts it.
Well, indeed, my Lord. And of course, there's consistent and guidance. And my Lord, I was going to go to only... There are a number of authorities mentioned, and I hesitate to reach for the authorities bundle, but...
Which one are you reaching for?
The green one, my Lord.
Yes, but which
Oh, Perry's. Perry and Rayleigh's.
Well,
I mean...
All right, well, we'll limit you to one authority because we're all pretty familiar.
Well, that's why I'm hesitate.
Right. Perry...
and I'm only going to... and it's at tab 5, my Lord.
Well, Henderson and Foxworth is the one people are frequently... Henderson and Foxworth is...
Yes, of course. But the convenience of Perry means that we're not going to skip through lots of authorities.
Because it summarises them all.
Lord Briggs deals with it all from page 75.
Right.
And I'm not going to invite your lordships to read the passages through to 52, but to merely identify that at the bottom of page 75 is the Henderson case mentioned,
yeah.
And of course indicating that this is a review even if the court were to take a different view. Then over the page, Lord Reed
McGrady, yeah,
explaining how important it is to assess the credibility of the witness, and that reported from Canada at little e. And then from Fage, Lord Justice Lewison warning against island hopping and the atmosphere of the courtroom not being able to be recreated. And my Lord, this is our case entirely. I mean, it is as though Lord Briggs was talking directly to my learned friend and warning him of the dangers of his approach. And that's the first problem that he faces. And the second problem is, what's the claimant asking this court to do? Because we had no indication until my learned friend stood yesterday that a retrial was being sought. That the box isn't actually ticked on the appellant's notice, and that's certainly not the tenor of his skeleton. That there was nothing in the skeleton that suggested that these were just matters which were seeking a retrial. Well,
if the claimant was saying that not only should the appeal be allowed, but an order should be made in the claimant's favour,
yes.
What in effect is then saying is that the conclusion reached by the trial judge was simply perverse, and no other conclusion than a finding in favour of the claimant was justified.
And where we are...
I don't think Mr. Booth went that far,
well,
at least on causation.
Well, exactly. My understanding, my Lord, is that he did go absolutely that far on this ground. So
yes,
on this ground...
He said yes.
Yes.
He said the only justifiable conclusion is a finding of negligence.
So I think you are being asked to find... Negligence on the part of it. And of course, it becomes much more complicated by the time we, for example, have timelines being presented to the court without any explanation either in themselves or indeed yesterday as to how one could possibly expect the court to do anything with those. But we'll
can I just be sure that how you understand it? We are being asked, I think you just said, to find breach of duty.
Yeah.
that Dr. Tanner got it wrong, are we being asked, so far as you understand it, to determine causation?
Well, I think you...
Because technically you're not liable for negligence unless you've suffered any damage.
But my lord, my understanding is that as far as D3 is concerned, breach of duty is being sought. I understood that the second ground, which is the issue of factual causation in respect of what would happen if they rang up the hospital, is also a matter which I thought a specific finding was sought. And I also thought, in far as causation on the medical legal causation, I think that also is an actual finding being sought. What perhaps is not within is sitting down and analysing together the 54 steps that appear in the 3 timelines which are before the court. And that's the area which would be left over or sent back to the judge, having, I think...
But does it matter? I mean, it might matter for apportionment between defendants, but in terms of the claimant's success, if he succeeds on liability and causation, he succeeds, doesn't he?
Well, yes, so I've been imprecise there. He has to proceed on several steps of causation to succeed in his case entirely. So whichever way one wants to do it, the first issue of causation is what would have happened.
Yes. Just
in terms of timing. When would the decompression have occurred? That's the end of the pathway. But if, for example, the court or a court was to find decompression at 2 o'clock, that raises this whole legal medical causation issue as to when was the deadline by which it was too late to turn anything around. So I think that if the claimant was successful in his appeal entirely, we would end up in a position where it is said that the third defendant is in breach. He should have referred to A&E. A&E would have accepted him. So to orthopaedics, and orthopaedics would have accepted him. And there is a time by which he ought to have been operated upon and decompression achieved. And then actually how that all pans out in terms of precise timings is something which will have to be sent back to the judge. That's as best as I could analyse it. So, my lord, can I turn then to ground one, the follow-up point? So 1A, which is the follow-up point and the NICE guidelines. And of course, in order to respond to it, I have to island hop selectively to bits of evidence to counter the island hopping that we are facing. And what is said is that the judge misunderstood the NICE guidelines and failed to appreciate that the claimant's case rested on the claimant being a follow-up patient and therefore fell under the second part of the advice given on old page 10, if I can call it that. I think by the afternoon, my lord, that the claimant's case had moved back to that position, that it was to do with the fact that Mr. Hewes had previous treatment. And the points that are relevant to this is, as I've already indicated, this formulation, reliance on the previous history, forms no part of Dr. Swale's, the claimant's expert evidence, not a jot. And the formulation was not put to Dr. Tanner. But after Dr. Swale had given his evidence, my learned friend Mr. McLeish attempted to elicit the evidence for that argument from the other witnesses. Mr. Thorpe, to some extent, obliged his own witness by changing his evidence to focus on follow-up. And I'll make that good, my lord. So this was a late lawyer-driven analysis. We probably have them open already, the guidelines themselves. Not drafted by a Lincoln's Inn lawyer, but probably worth seeing precisely what they do actually say. So tab 33 of the charcoal bundle. And if we could turn first to page 313.
and there's a heading, when should I suspect sciatica? And before it tells you when you should suspect sciatica, it says, work out whether there are any red flag symptoms. So that is going to be a theme. Whenever you're managing sciatica, the first thing you think about is whether or not there are any red flag symptoms. And if one then goes over to 315, one gets scenario management. So this is now old page 7. Question asked, how should I manage a person with sciatica? And before it answers that question, it says, well, are there any red flag symptoms? Because if there are, admit or refer urgently for specialist assessment using clinical judgment. So we, in our schedule, we clumsily call that advice A. But that's what you do when you are managing sciatica. If there aren't red flag symptoms, then there are a lot of options and advice as to how you do manage the patient. And if one goes down to an inch above the bottom where it says, for people assessed at higher risk of a poor outcome,
Yes.
and if you go 2 bullet points above that, there's a sentence beginning, advise the person to seek follow-up.
Yeah.
So advise the person to seek follow-up if symptoms persist or are worsening after 1 to 2 weeks. So that is the situation in which follow-up arises on this paper. You've managed someone with sciatica and you tell them, if it's not better in 1 to 2 weeks, come back and see me. And then if we turn over to page 318, we get to the section follow-up. And one sees there, underneath the heading follow-up, in bold, at follow-up if symptoms persist or are worsening. So that ties in with the recommendation that we've just seen for management of sciatica. But again, even at follow-up, if there are red flag symptoms, before you do anything else, consider red flag symptoms, and if there are red flag symptoms, then send off for specialist assessment. If there aren't, then carry on with the management. And then we get to the paragraph which I believe my learned friend still relies upon, which is, in the management of the sciatica, consider arranging specialist referral. So it's not a mandatory obligation. If there is progressive, persistent or severe neurological deficit, admit or refer urgently to neurosurgery or orthopedics. So one sees that's a narrower range of referral for this situation. Nothing surprising about that because you're dealing with sciatica getting worse, and therefore those are the appropriate specialities, depending on clinical judgment and local referral pathways. So it's said that that was the mandatory instruction to Dr. Tanner, applicable to Mr. Hewes, which the judge was wrong not to accept. And so it must be being said that not only was Mr. Hewes a follow-up presentation to Dr. Tanner, but also that his condition was one of persistent, progressive and severe. And we'll have to see how that was dealt with or not dealt with in the evidence. But we submit there's no evidence from any physician, clinician, that numbness in the testicles, which had been present for an hour and which had not changed in that period, and was by definition not painful, was persistent, progressive and severe. It was, however, definitely a red flag.
Well, we know that because Dr. Tanner viewed it as such.
Of course.
So, but what matters in cases of this kind is that you have your MRI scan speedily. And what might be said is the risk of sending to A&E rather than orthopedics might mean you end up with a very overworked, busy doctor who's frightfully good on burns and broken limbs, but is not so strong on neurological cases, and might say, this seems all right to me, you don't need an MRI scan, or wait 3 hours, something like that. But here, Dr. Tanner's view was there was appropriate expertise at A&E, and in the event, as we know, an MRI scan was ordered.
Yes.
But isn't that possibly what's underpinning the concern about sending to A&E is you will not have a doctor there who will understand the urgency, potentially, for CES cases?
Well, the answer to that is,
You
first
might
of all,
say, firstly, not this case, you might say.
first of all, well, I wasn't going to say that, but I was going to say, first of all, one's looking from the GP perspective. So it's well established, and one only needs to think of the two papers the two short extracts that I've taken you to, that it's considered that A&E clinicians can deal with an MRI scan and cauda equina syndrome. And there is evidence that we will see from, well, I mean, it's, in a sense, it's obvious, because Professor Fairbank's idea is get them down to A&E where they can be scanned, assumes that they can scan them. So that is absolutely bread and butter for A&E to work out whether or not a potentially serious condition exists, which then needs to be referred to a specialist unit.
Was there evidence of how many CES cases the A&E department at WGH had per year?
Indeed.
Because Dr. Tanham himself said he saw it. Was it one every 2 months?
Something like that.
And if that's so, then A&E probably sees them on a far more regular basis.
Well, of course they do, because only 20% of them actually are confirmed.
Quite.
So, I mean, I should say, subject to Dr. Swales being right that no one ever refers to A&E, but that just isn't right. But that's, of course, right. And Mr. Langdon's evidence was that there were about 800 cases at Watford a year, about two to three a day.
That's it, yes. Yeah.
So 2 to 3 a day. So, my lord, how was the case advanced? Because I have at the back of my mind that the criticism of the judge is that she concluded that this case hadn't been put to Dr. Tanner and had never been advanced in this way. So we need to look and see how it was put. So if I could ask to turn up the second supplemental one, which is light grey, and go to a passage which, behind tab 9 at page 130, using the numbering in the middle of the page. It's a passage actually we went to yesterday.
Yeah.
And what is important here is that although the lower advice is certainly put to Dr. Tanner, so if one looks at the top of the page, yes, if you turn to page 10, bottom of the page, so that we now know is the persistent severe advice.
I'm sorry, Mr. Anton, which page are we on?
I'm sorry, 130, using the numbering in the middle.
Yes.
Bottom. And the top of the page, my lord.
Yes.
So, Mr. McLeish asks, so in cases where you have progressive neurological deficit, that may require, I think, with magnetic resonance imaging, it's a referral to neurosurgery orthopedic. So the answer is, well, can you give me a moment? We've seen this yesterday. I'm not going to read it again. Dr. Tanner says, well, no, I think this is a red flag situation, so I would have gone for the red flag advice. Now, if the crux of the claimant's case is, well, hang on a moment, this is a follow-up patient, he's been seen by orthopedics before, therefore you have to act differently, which, as I understand it, after lunch was the clarification given by my learned friend. That needed to be put to Dr. Tanner, and that never was put to Dr. Tanner. There is no suggestion that this claimant needed to be treated in any other way because of his medical history. And this is a professional negligence case in which, in my submission, it's of paramount importance that the professional has an opportunity to respond to the allegations against him.
And are you saying this was not pleaded?
It wasn't pleaded, no. And I'm pretty sure of that without checking the pleadings, because the thought only came to the claimant's mind 2 pages later in the transcripts. Because what happened, and my Lord Justice Davis picked this up, that in re-examination by Miss Woodbridge, starting on page 132 at E, we get to follow up on page 6. So this is if you've already managed that individual in practice, and then you're seeing them again. Yes. So she rightly was picking up that this section probably didn't apply. And I would say it's a leading question from Miss Woodbridge, but that's not a criticism, because in these circumstances, it ought to be a completely...
Re-examination is always a series of leading questions.
But also, it was probably, it was actually intended, as I understand it, and one would have thought to just be a clarification, would not thought to be controversial, that this was then going to be the whole of the claimant's case. So one sees how that came in. Then we need to turn to Dr. Swales, because this is the expert evidence that's relevant from the claimant on GP conduct. And we need, I'm afraid, to go to the charcoal bundle now.
Do we put aside light grey or keep it open?
I think we'll put it aside for a moment,
Okay.
but not for long, I'm afraid. There's a bit of jumping around. But I've tried to, at times, pick up other points en route so that we avoid too many. Tab 11. This is Dr. Swales' report. And if I can invite the court to turn first to page 45. Now, in saying that the judge was wrong in considering that this hadn't been put, it was said that's, well, I think it was put in fairly intemperate grounds. Of course it was part of Dr. Swales' case, because here at 4.06, he's quoted that passage. Well, what one sees, of course, is that at the top of 4.06, first bullet point, is our red flag situation, which actually is emboldened.
Yeah.
And then there is the second part of advice, not emboldened, but sits there. And then there's advice set out about referring to a pain clinic or to physiotherapy. So there's nothing here to say, oh, this was a follow-up case. One doesn't get that from that passage. And then at the bottom of the page, on page 52, page 52, bottom of the page, one gets a completely clear view of what Dr. Swales' position is. In that last paragraph, just about your court to read that, beginning, in my opinion, based on nice guidance.
With a new red flag.
Indeed, with a new red flag. I mean, and nothing about Mr. Hewes' history. And I would say as well, no suggestion that there was a progressive, persistent or severe neurological deficit. It's a red flag situation, end of story. And then if one turns over to pages 53 and 54, Dr. Swales gives a list of reasons, that they are narrowed by the time of the trial, but it's all those bullet points. And all of the advices, A, B, and C, if I can put it, are set out and not distinguished between. There's no question of follow-up raised, but I do need to draw the court's attention to the third bullet point where he sets out the second advice. The words after that, in my opinion, all reasonably competent GPs will consider that cauda equina syndrome fits into this category due to its severe nature. Well, my lord, I don't think anyone would disagree from what we've heard about cauda equina syndrome, that it's at least progressive and severe. Whether it's
I'm so sorry, Mr. Antel.
I'm sorry.
Missed where that passage is that you just read.
So
My fault.
page 54.
54, yep.
Third bullet point down, starts nice guidance reference,
Yep.
quotes the...
Oh, I see, got it.
and then it's just the sentence
Thank you
after
so
that.
much.
But the difficulty for Dr. Swales is that Dr. Tanner wasn't dealing with a case of cauda equina syndrome. He was dealing with a red flag for potential cauda equina syndrome. So there was nothing for Dr. Tanner to decide that there was a progressive, persistent, severe. He had someone who had numbness around the testicles. So he doesn't fall into that category at all. Then at tab 22 of this same bundle, we get to the joint meeting of the GPs, and page 242, if I could invite the court to turn to that.
On how many occasions had Dr. Swales himself referred directly to orthopaedics?
Twice. And it happened very quickly. But they were, in fact, both not out of hours situations. They were his own patients or patients of his practice. Page 242. Second paragraph of the answer. Dr. Swale will say direct referral to orthopaedic or neurosurgical specialist for assessment would be necessary. So I'm sorry, I should have identified the question first. What would the treatment be if a red flag for CES is identified? And then it's Dr. Swales refers to the NICE guidance, which states that GPs should urgently refer patients with suspected CES for specialist assessment. Nothing about follow-up or previous history. My Lord, could I just ask the court to turn to wrong restroom. No, tab 27 of this bundle, please. I'm going to go to Dr. Swales' oral evidence next, but I need to identify a passage which was put to him so that his evidence makes sense, and that's at tab 27 of the same bundle. This is a paper from the British Journal of Neurosurgery from 2007. What is important in this is at page 285, second full paragraph on the left-hand column. The majority of episodes of cauda equina syndrome in the United Kingdom will be referred from primary care trusts, that means GPs, but we'll see that in the evidence, to either accident and emergency departments or to local orthopaedic departments. And my Lord, I want to now take the court to how Dr. Swale deals with that. And it's now the light grey tab. I don't know whether that was a long enough gap to justify putting it aside.
Yeah.
Page 222, numbering in the middle at the bottom. 222. Well, perhaps I start at 221 just to make sure the context is clear. Under little between B and C, you see Miss Woodbridge puts the paper I've just identified and that particular passage. And there's a little bit of back and forth because Dr. Swale's initial answer is, well, that's a specialist journal, so GPs wouldn't know about that, although it's difficult to see. That's my telescope point. You can't have all the GPs referring to orthopaedics, but orthopaedics are not ever taking them. And if one turns, therefore, to 222F, the judge is asking questions here. And perhaps just at E, middle of that answer. What I'm suggesting is that statement implies...
So which page are you on?
Sorry, 222.
222, yep.
Yeah, just between E and F.
Yep.
You see one word in the sentence beginning what I'm suggesting?
Yes.
That's the judge asking the question, referring to this paper, and that she is saying, well, that seems there's a range of opinion and options open to the reasonably competent practitioner. In other words, A&E orthopaedics. To which Dr. Swales answers, I think the problem is that GPs will, well, a lot of GPs will do certain things, but that doesn't mean that's right. As an aside, it would appear at that point that a case based on Bolam was probably untenable thereafter, because what Dr. Swales seems to be saying is that it does reflect a practice, but his view is it's a bad practice. case. And over the page at 2223C,
Well, if it's a bad and illogical practice, then it's no justification.
then it's Belitho.
Right.
Quite. But we're moving
No,
in.
that's precisely what Mr. Booth would say.
Well, I think absolutely. I think he does. He does rely on Belitho, or must rely on Belitho. I would say, because his evidence has been his evidence on Bolam. It seems to be
Bolam sets the bar very high for claimants, as is known. But one thing Belitho has done is he's completely shot to pieces the defence, but that's the way we've always done it. And a lot of people say, and a good thing too, that is.
and prevents a judge just saying, I've seen two experts, and one of them seemed very charming, and so
and that's the way that's the way the claimant, Mr. Booth, has approached it.
Yes, and Belitho, of course, is one of the grounds of appeal, and we'll look to see whether the judge took that simplistic approach. So at 223C, we get to the end of that passage in which he says, well, I agree it's a range of options, but I think my opinion is based on logic. So exactly, my lord, that's where he's gone now, in that I don't think there's any logical reason to send a patient to A&E, and there are plenty of logical reasons to send them direct to a specialist because you can avoid delay.
One logical reason to send to A&E is you might get your MRI scan quicker.
One of probably logical reasons to send to A&E, my lord, but I can't make all the submissions in one together.
Plenty of logical reasons.
So what we have here is a situation in which, to be fair to Dr. Swells, he is completely clear in his view, but it's got nothing to do with
one logical approach, and I think maybe his approach is, if you send to A&E, all you're doing is prolonging things, because A&E will then refer up to the specialist anyway, so you're losing time. That may well be...
That's his thinking.
Yes, well...
But that's
thinking open to him, isn't it?
Well, it's wrong, my lord, and I'll explain why. I mean, if you've got to have an MRI scan, the first thing you've got to do is have the MRI scan. Once the MRI scan has given a result, then you need to be referred up to orthopaedics. There's nothing implicit in that means that the process will be longer or shorter, depending on who organises the MRI scan. I mean,
I come back to my...
I was going to say, in this case, I'm trying to remember what actually happened, but it didn't go straight from Dr. Ruffy to MRI. It went via Dr. Kirby.
Of course, this
was in orthopaedics.
Yes, this case, in this case, it went to Dr. Ruffy. I can't say precisely what he would have done if he hadn't dismissed the possibility of cauda equina syndrome. So Dr. Ruffy carried out an assessment and decided there wasn't cauda equina syndrome. So he referred on anyway, because there was a neurological deficit, to orthopaedics. Orthopaedics came in and went, hold on, there is potential cauda equina syndrome. So Dr. Ruffy then organised an MRI scan, or filled in a requested one. So in this particular case, one could say, well, if it had been Dr. Kirby first, well, maybe some time would have been saved.
But it would have been saved. And I take it is the underpinning of what Dr. Swells is getting at, is you preclude the risk of having A&E not appreciating this is CES, urgent, etc.
Well, my lord, we're back to the answer that I gave your lordship a moment ago, which is that it's clear from A&E perspective, from orthopaedic perspective, from the neurosurgeon's perspective and the neurological surgeon's perspective, that A&E is an appropriate place.
Is one appropriate, yes. And you say clear from the literature.
Clear from the literature.
Some, I mean, again.
Let's assume, I couldn't understand, and I'm not perhaps concentrating quite as hard on this aspect of the case but as I understood it, there were no criticism of Dr. Ruffy, and then yesterday I heard something about barn door negligence, so I'm not entirely sure whether he's being criticised or not. But the answer is, well, you could have had Dr. Kirby as the first person to assess. She's much more junior than Dr. Ruffy. Well, if you have a junior doctor, there may be a miss. But the reality is that when one's looking at the two situations, and the contrast that I would make is this: Monday morning, GP sends down to A&E. A&E is relatively empty. Patient is seen within 15 minutes. Junior doctor, perhaps not an FY1, but someone more senior, sees them, says, oh, there's a red flag here, let's get an MRI scan. All done in half an hour after arrival. Alternative, ring up orthopaedics, someone will ring you back. They ring back in half an hour. You get down to orthopaedics, there's a single doctor on call, she's got a crisis in surgery, she doesn't get to see the person for an hour and a half. I mean, that's how, there's no absolute suggestion that going to A&E will slow things down. And the reason for that is not me just saying, oh, well, you can't be sure. It's because both departments have to do the same things first. Both departments have to do the MRI. Once the MRI is done, both the orthopaedic department and the A&E department have to then get a surgeon involved to decide what to do next. And whether that would be quicker or not is a matter of chance more than anything else.
Was there any evidence? I mean, one understands that A&E is set up to receive people who walk in off the street with no previous history and to triage them as soon as you reasonably can and then decide what to do. But was there any evidence as to how the orthopaedics department is set up to receive people where there's a sort of GP rings up and says, expect somebody?
I think, and again, it's not my hospital, but I think the situation is this, that if a patient had been accepted, they would have arrived at A&E, but would have been assessed in a different unit, AAU, acute admission unit, I think, which is a different part, and presumably they would have arrived at A&E and there'd have had to been some discussion or some kind of triage at that point just to identify them, and then the orthopaedic team would be bleeped, and when someone was available to come, they'd come and assess them first. That's my understanding of what would occur. I don't know whether... I will probably just ask those next to me whether I've got that right in due course, but that's my understanding. So there is a route by which a patient could arrive, in a sense, with a ticket saying, I know that I've got to see orthopaedics. So orthopaedics would see them as soon as they could. Whether that would be quicker than be seen by the A&E doctor or not, it's a matter of entirely of speculation. Contrast the situation. If the first thing you had to do with suspected CES was perform surgery, then one can understand you want to get to a surgeon. But that isn't the first thing that you need to do. The first thing you need to do is get an investigation, a history, and a scan.
What would have happened if Dr. Roffey had suspected CES?
Well, I don't know, but I guess. But from the GP perspective, so I could say this, from a GP perspective, he'd organise an MRI scan.
He wouldn't have to route it through orthopaedics.
No. Just get on with it. Well, yes, I'm being reminded that in practice, although it's a little blurry, this history, because it's, and that's not a criticism, it's a little blurry, because in practice, by the time Dr. Roffey requested it, in fact, he had already spoken to orthopaedics. But the request was made by Dr. Roffey and signed off by the consultant, not orthopaedic consultant, A&E consultant. It was an A&E request for MRI.
It was Mr. Mackenzie.
No, absolutely not. Because Mr. Mackenzie is orthopaedics. There was someone called Dr. Cheetham, who was a consultant in A&E, supervising Dr. Roffey. Well, that is the end of the claimant's expert evidence on GP conduct. And although this case is said to turn on the fact that he had a previous history, it doesn't appear anywhere in the expert evidence which ought to address it.
Well, I think your arguments would be the same in any event, wouldn't it?
Well, the substance of it is
the same.
I mean, but I'm having to respond to the... but of course, what we're doing, I hope not unhelpfully, is that in responding to this ground, we're actually identifying the elements that go to the picture, the wider picture, the wood rather than the trees. and I'll be able to be much quicker when I come to the other grounds.
Can I just understand? You've made the point that the follow-up point wasn't really the case and wasn't put to Dr. Tanner, and that ought to stop it in any event. But if it was open to the claimants, do you say that on a true understanding of the NICE guidelines, Mr. Hewes was not a follow-up patient within the meaning of the guidelines, which seems to be in Dr. Tanner's view?
My Lord, if one were considering the merits
Yes.
of the NICE guidance point, the first point is it's only one document of a range of documents. So it's not a statute, it's not a regulation, it's not even mandatory guidance on the management of CES. It's a document about sciatica with a signpost if red flags arrive. And so one can immediately say, well, other guidance, which would include, for example, the BJNS paper, tab 30, which we looked at, would in my submission, make a finding of breach of duty impossible. Second, we do say that the claimant misreads NICE. The starting point and finishing point is red flag for this. So the follow-up, in a sense, doesn't really matter, because in either section, management scenario or follow-up, the starting point is red flag to specialist assessment. What we do, in fact, rely upon, if it were a contractor we were construing it, is that the guidance in respect of red flag is wide specialist assessment, whereas the guidance in respect of progressive, persistent and severe is narrow, neurological or orthopedic. And if it were a contract, we would say that indicates that the earlier advice is wider, and we would say therefore is consistent with it being properly understood by Dr. Tanner, Dr. Russell and the like, that it includes any, and that would also be consistent with the wider sea of evidence. We would also say that the whole follow-up argument is entirely artificial in terms of reasonable management. There is no relevance in this case to the fact that Mr. Hewes had a medical history. And we saw a passage from Professor Fairbank on that yesterday, and I probably will return to that. But, well, actually, I'll come to that in just a second, because he identified that one could see follow-up being of some relevance if you were going to see the same doctor. He said it could be of some relevance if you were going to have access to the previous notes. But in this case, the reliance on follow-up is treatment by a Mr. Dyson, who, as it happens, was off sick, in a hospital in Hemel Hempstead, who was dealing with sciatica, compared with a red flag being dealt with at orthopedic department at 6 o'clock in the morning in Watford. And so I think it was said that it was evasive of, maybe it was Mr. Langdon, to answer the question, well, he was a follow-up patient, and we'll come to that, but he was a follow-up patient. To say, well, hold on a minute, he wasn't going to come to my clinic. You know, I didn't have the notes. And they say that's evasive. But in fact, he's just saying, well, okay, well, if he's a follow-up, what's the relevance of that? And of course, those are the very words that Professor Fairbank used when he was uttering. What's the relevance of that? And nothing has been said to suggest that it would have altered management in any way at all. So it's entirely opportunistic.
Do we need to resolve whether the judge was right that A&E is a specialism?
Well, if my learned friend is saying it isn't a specialism, first of all, let's hope he doesn't have an incident that needs him to be in A&E, and he makes that observation. But, my lord, we will see. Perhaps I'll take your lordship now to Professor Fairbank's evidence, because it's quite a convenient way of looking at it, where one will see time and time again the ability of A&E to undertake the scans. And again, that's reflected in the literature. I suppose the real question is A&E sufficiently specialist in this particular context. Because, of course, it's a slightly odd question, isn't it? One wouldn't necessarily want to go to A&E for advice about building problems. But you can go to A&E for specialist investigations such as MRI. And, of course, before I turn to Fairbank, of course A&E is a specialism.
Yes, but the question is, when the NICE guidelines say if there's a red flag, refer for specialist assessment, well,
yes.
That includes A&E.
Yes.
Yeah.
And it must do. Or, put another way, it would be a very odd reading of the NICE guidelines in the context of the other literature and papers that exist to suggest that they were trying to give an instruction here, mandatory, do not send to A&E, which would be quite an easy instruction to give. But, my lord, the Fairbank evidence is...
Just again remind me, before Mr. Hewes actually attended A&E, had there been some form of notification to an A&E that he was a suspected CES case? There hadn't. So he simply would be turning up.
He would be turning up.
So they would have to make their own diagnosis afresh. We know what Dr. Tanner had thought.
Yes. One needs to be slightly careful. There was no diagnosis by Dr. Tanner.
No, but
he had been told.
He put double query, didn't he?
He had been, well, which is absolutely right. He couldn't have made a diagnosis, but he had. The claimant presented saying, "I've got really bad pain down the leg and in my left buttock," and Dr. Tanner elicited that red flag. He wasn't proffered it. He said, "Now, is there any numbness anywhere?" And not really the leg. And then he elicited it, and he realised that's a red flag. So he goes, "Get down to A&E." There's no diagnosis, but he realises.
No, I expressed myself badly.
Yeah.
But,
so they do have to take that history again.
Yes, but the A&E would be working without knowing that Dr. Tanner had suspected a red flag.
No, that's exactly right.
They would start from scratch.
Yeah,
and Dr. Swale would say that, and that's the risk.
Well, I don't think he would say that. He would say that. Sorry, he would say there's important transfer of information.
Absolutely. Yes.
But he also agreed that, as it happens, Mr. Hewes was someone who was entirely capable of giving an accurate history. So as soon as he arrived at A&E, he would have given the history in exactly the same way as Dr. Tanner would have to give it. That he's got this numbness and he's been sent down here as an emergency. And of course, that history would have to be given to whoever saw him first.
And presumably, I rang up an out-of-hours doctor.
Of course.
He told me to come to A&E.
Yes. That is exactly what would be said.
Right.
And he told me to come because I've got numbness around my testicles.
And A&E departments, one can take from the evidence, routinely see suspected CES cases.
Of course they do. And they see,
but
regardless of this issue between us, some people will go to A&E directly anyway. So it's important to remember that a proportion of people who go with normally, of course, they attend with worsening sciatica. Whichever other, but let's stick with sciatica just for convenience, because I think there are other elements as well that could be. But they turn up at A&E with worsening sciatica and go, it's really, really bad. And then the doctor has to elicit or note the red flags. So the idea that A&E, even if Mr. Dr. Swales is right, that somehow A&E never come across people who they have to identify and process on the basis of red flags is a nonsense.
And presumably they read the NICE guidelines as well, the doctors in A&E.
Of course. But I think somewhere in the evidence, one of it says, cauda equina syndrome is bog standard medical training. Something that can go wrong from what appears to be a reasonably straightforward. Lots of people have backache, but there are some nasty complications that present as backache, which are much more serious. And it's exactly the same as A&E. The child who goes in with what looks like a perfectly ordinary viral infection, everyone has to know that the chances are it is a perfectly ordinary viral infection, but some people have meningitis.
Could be meningitis. Yeah.
That's what emergency departments do. That's their, in a sense, that's their forte, is identifying the uncertainty. 292 in the grey bundle. So this is Professor Fairbank, and there's a passage, and if your lordships had time for a little reading, I would recommend 292D to 296D in due course.
This is the examination of...
Cross-examination of Professor Fairbank. And one of the reasons why this is a very useful 4 pages is because by this stage, Mr. McLeish had well in mind the arguments he wanted to run on follow-up and so forth. So all the questions are there, but you also get all the answers to those queries. And it's, as the judge found, Professor Fairbank was, as one might expect, an impressive witness who didn't really have an axe to grind and gave a straightforward answer. So if we just... I'm just going to highlight...
Oh, well, none of the expert witnesses have access to grind.
No, that's absolutely right. Absolutely right. I think I probably conveyed that. Yeah, I think he said in particular he was remarkably frank, happy to take, identify the imperfections with his system at his hospital, but that being the best that there was. So at 292, next to little d, he's being asked about if patients are sent to his department and red flags. And he says, well, I would say go to A&E because that's the most reliable way in a really complicated system, both in primary and secondary care, which that patient has to navigate. Now, if that patient's gone to see, in this case, an emergency doctor, then in my view, the sensible thing is for that doctor to refer the patient to A&E as he has done. And then he says, the problem is saying, okay, you need to go back and see Mr. Dyson, is that that doesn't work. And then he's going on to say that he couldn't have arranged a clinic. And then this passage, I think, we went to at the bottom of the page yesterday, because I think my Lady Justice Laing said, here's the judge understanding the position of the question of on factual causation. And over the page at 293 under little b, you see how he says at line 4, so how would it be relevant? And he expands on that in a very sort of vivid way. As to, what is it that you're trying to do because he's a follower? And then if we skip down to just about F, just to the right of that, a sentence beginning, so I would say that I would still stick with the same policy. Look, the best way of getting there is through A&E. They can assess the patient, they can contact the orthopaedic scan. As we've seen here, they can request an MRI scan. As in fact, in our much disputed policy in our hospital, that's what they're asked to do, scanning and organise. So that's what A&E departments do. Then it's put again by Mr. McLeish, well, he was a follow-up patient. And Professor Fairbank says, well, I don't think that makes more sense with respect. He's been under care for disc herniation. And then end of, just opposite C, however skilled a clinician you are, at the end of the day, you need to get a scan done. So it's quite different from what's going on in an elective outpatient. So he's identifying, in the context of his hospital, you've got to get that scan done. While we're here, if I could invite the court to turn over to 295, taking slightly out of order. The question is put to Professor Fairbank, well, that would going to A&E would cause an inevitable delay. And he said, well, I've heard the arguments about delay, but I don't accept that. What I do is accept that whatever your system here is for dealing with quite a common problem, 800 a year, 2 to 3 a day, seems you've got to get a scan. And then there's got quite a nice answer, I suppose. C to D. So would you agree that if a referral to orthopaedics would reduce the time taken to get the scan, then it's logical and rational option in this case? Which of course is not the right question, because it may be logical and rational, but it's whether what Dr. Turner is illogical or rational. Well, I'm saying that I don't think that is the case. If you can show me that they would have been such more quickly, But that's not my experience, and I'm standing up here because I'm experienced. And just for references, that's entirely consistent with his report, which is at, I'm not going to turn to it, at S1, tab 14, page 138.
Page 1.
138, just under little Roman 4. And then the joint statement, which we did see yesterday, in which he gave the answer, it's widely practiced to centre A&E. Now, in answer to my Lord Justice Nugee's question of, well, what's the substance of the NICE guidelines, I had, I turned away from the history, lengthy as it is, about how the point developed. Because it's, and I'm nearly there on that, but of course, I need to just take to Dr. Russell and Mr. Thorpe just to complete the picture. Because Dr. Russell was asked this obliquely in cross-examination, and if I could invite the court to go to tab 10 of the light grey bundle. And if we start at 236F, Mr. McLeish says, well, surely the right specialism for cauda equina syndrome is neurosurgery, spinal surgery, and orthopedic. Dr. Russell says, well, I completely agree. Once the diagnosis has been made, that's when one of those specialities must take over the care. So making that correct distinction. And then at the bottom of the page, Mr. McLeish takes Dr. Russell to page 10. And if you look to the bottom of the page, urgent neurosurgery, orthopedic referral. And the answer over the page at 237B to C, and then D. So that full answer is Dr. Russell saying, well, he wasn't follow-up, and it doesn't seem to apply. And he says, well, people might take a different view on it, but that's his view. And then over the page, at 238, Mr. McLeish asked the same similar question again. And the point about follow-up, Dr. Russell, is this. And then he gives the history and says this man was a follow-up patient presenting with a red flag for cauda equina syndrome. Of course, there are two elements to that question, to which he answers, I would agree to that, my lady. But then goes on to say, but this is a red flag situation. And of course, what is not put to Dr. Russell is this is progressive, persistent, and severe. So this is perhaps, if I may put it that way, the high point of the claimant's case, because they get something of a concession at its highest, although one might wonder which bit of the answer he was given, that in general terms, Mr. Hewes was a follow-up patient and he was under care from somewhere else. What isn't finished off is whether that man dated an approach under the NICE guidelines to be in the follow-up section, or far less to be in the lower advice of that. And then finally, in this review, I need to take your lordships to Mr. Thorpe. And if we just go over one tab, to tab 11, and it's page 254. And from the top of the page, he refers to an intervention by Mr. Langdon, and he says, 3 lines down at the end, then it would have been reasonable and common practice for it to be accepted as an orthopedic expected patient, and had the patient no contact with the unit and not been seen before, then it would have been perfectly reasonable to send it, that's the patient, to the emergency department. So that is the nuanced view of Mr. Thorpe, that the other end of the telescope, you can reject a patient if you're in the orthopaedic team in normal circumstances, but if they've been a follow-up patient, then it becomes unacceptable. And you can see I have to deal with this again in ground 2. But what's striking in my submission is that if one puts away the light grey bundle and goes to charcoal, and we see how Mr. Thorpe put it in his report, tab 12,
Just before you put that away, when Mr. Thorpe says had no contact with the unit, does the unit mean WGH, or does it mean WGH and Hemel Hempstead because it's all one trust?
The evidence, well, I don't know, but we know that the trust is described by Mr. Langdon as fragmented. Most of the clinics, as I understand it, occur at Hemel Hempstead. There's another, could it be St Albans, is another location where, and there is a unit or a presence at Watford. And I think that people do, within the orthopaedic team, appear at more than one place. I'm not sure they all go to all places, but we had some history that, for example, Mr. Langdon himself happened to be at Watford that day. In other circumstances, he might not have been there at all. He might have been doing his clinics in Hemel Hempstead. So, the Lordship identifies a point which, when we come on to ground 2, and whether or not it would have been unacceptable for the orthopaedic, the hypothetical orthopaedic person to reject. There's lots of talk of belitho, but in my submission, and I say this reluctantly because I don't want to mention logic in the Court of Appeal and then find I'm in trouble, but it does seem to me that Mr. Thorpe's evidence is simply this. A, he's a follow-up patient. Therefore, B, he must be referred to orthopaedics in circumstances where A and B have no connection with each other. And in my, if you go A, therefore B, and they have no connection with each other, that's illogical. So that's Mr. Thorpe's position. And he doesn't distinguish between the unit because there's nothing in the substance of it that has any relevance to this at all. There's nothing to say. I mean, one can imagine a situation in which someone has a blood complaint and you've got a specialist store of specific blood for transfusion. I'm making this up. And you know, the GP knows that there is that specific blood in one location. Don't send off to another location. But there's nothing here in any of the evidence, and that, or can one think of, any advantage in the treatment for Mr. Hewes, which would arrive, or that alters the way in which he's managed. I was, my lord, I was going to turn then to his report.
Yes.
Charcoal bundle 12, tab 12. And page 86. So Mr. Thorpe was asked to comment on direct GP referral. And just perhaps in passing, I noticed he says it's common for GPs to make direct calls to an orthopaedic or neurosurgical team. If I were being overly lawyery, I think I would suggest that means that sometimes they don't, but the court can form a view. But down at 6.3 and 6.4, he deals with unreasonableness in an orthopaedic team rejecting the claimant. And he says it would have been unreasonable to reroute the referral to A&E. And there isn't a single mention that this is because of follow-up or previous treatment. It's a blanket assertion that orthopaedic departments should not reroute to A&E. And it is only in his oral evidence that he changes that to say it's perfectly all right for a GP to reroute to A&E unless they've been seen before. So that was the story of this part of the claimant's case. And so if we turn to the judgment, paragraph 46 in the call, I suspect we've all got it somewhere else. This is where the judge indicates that this distinction between pages 7 and 10 and the different advice was not the prism through which Dr. Swale was advancing his opinion. And that is said to be a fault on the part of the court. But in my submission, it is entirely correct and properly reflects the position. And it is difficult, with the greatest respect to NHS, to understand how they could say otherwise. But of course, this judge, as one might expect from the rest of her judgment, did not simply rely on that quasi-procedural position. It would have been sufficient for her, but at paragraph 24 of her judgment, she sets out relevant parts of the NICE guidelines, including the section relied upon by my learned friend. She refers to it, its meaning, and her interpretation of it at paragraphs 43, 45, 47, 49, and 50. So if we go perhaps to 43 first, she's talking about Dr. Tanner's evidence, and she identifies his response to that question. At paragraph 45, she's dealing with Dr. Swale's evidence.
Paragraph 43.
Yep.
Dr. Tanner had given evidence that he considered A&E doctors to be sufficiently qualified and specialist to arrange an urgent MRI scan to diagnose CES. Was it put that as a matter of generality, no reasonable GP could think that?
I believe it wasn't, partly for this reason, and I think I may have mentioned earlier, but I may not have done, that there's an extraordinary part of the evidence when Dr. Swales is asked, can an A&E department organise an MRI? And he says, that's outside my expertise. So when he says it's illogical, he's forming his opinion on the basis he has no idea, at least in the way he gives his evidence, as to whether or not that's right or not.
Maybe so, but I don't have the transcripts that I think it is on my court of view, but Dr. Tanner in evidence, as the judge records, considered AE doctors to be sufficiently qualified and special to arrange an urgent MRI scan to diagnose CES. Now, was that challenged as an unreasonable viewpoint for a GP to hold? And obviously, the NICE guidelines were put to Dr. Tanner.
I think it may have been put to him, and I think he would have. I think his answer was that's. Could you find it? Oh, I see. I don't think it's part of the transcript that is in the bundle.
All right.
But I think that what.
But it seems to be accepted that A&E departments, as here, are in a position to arrange MRI. Yeah. That seems to be accepted.
Yes.
So if Dr. Tanner thought that, he was in fact right.
Yes.
So was it reasonable for him to think that A&E doctors were sufficiently qualified to diagnose CES when he had himself observed a red flag on what he'd been told over the telephone.
Yes.
All right. Sorry, no, you 43, 44, 45, yeah?
Oh, yeah, sorry. So, yes, 45 is Dr. Swales, and so she identifies his reliance on the NICE guidelines and identifies correctly that his view that it would be illogical to result. At 47, she's now dealing with Dr. Russell, and at little 4, she sets out all the factors, including NICE, including the difference between specialist assessment and general assessment. At 49, it's a slightly different context, and then at 50, she's identifying a number of factors. But if you find second, which is about halfway through the paragraph, she's saying it doesn't distinguish between direct and indirect. And third, the NICE guidelines on pages 7 and 8 use different terminology as set out in paragraph 24 above. Arguably, this means it's reasonable to interpret special assessment according to clinical judgment as including A&E assessment specialist Dr. Swell, except as an A&E staff are capable of appropriately assessing and managing suspected CES cases.
Yes.
So the judge has got well in mind the arguments that were developed during the course of the trial. She's got well in mind the NICE guidelines, and she concludes, as we know, that didn't mandate Dr. Tanner to refer to orthopaedics. And my lords, I've already addressed now, in answer to my Lord Justice Nugee's question, the reasons why, if it's necessary, to sense check that conclusion against the many factors which point away from the NICE guidance being that mandatory provision. My Lord, we've covered a lot of ground in dealing with that ground, and I hope that I'll now be able to wrap up a number of things much more quickly, because ground 1B is the allegation that the judge hadn't properly taken into account Dr. Russell's inconsistencies, and that led to an exchange between my Lord Justice Nugee and my learned friend yesterday. And my recollection is that by the end of that exchange, my learned friend had conceded that the balance and weight to be put on an expert if there's some part of his report which is less persuasive than other parts was something exquisitely for the trial judge. I'm not sure it's still pursued, but I'll just flag up the key factors. This is because Dr. Russell said it was possible as an option to, if Mr. Hewes was minutes away, that he should attend the GP in person and then a decision be made as to what to do next. So we don't accept for a moment that would actually be unreasonable, but it's not an issue that was considered or had to be addressed by the judge. It's not this case. And as the judge recognised, it's not for her to find a black mark in one part of a report and then throw it out and unthinkingly accept another report. She has to look at the evidence as a whole and consider it. And of course, she noted expressly in outcries yesterday from this side of the court when my Lord Justice Nugee said, well, even if she hasn't mentioned it. And we went, well, she has mentioned it, because she had specifically dealt at 49 and 51 of her judgment with those very criticisms and concluded that they didn't impact on her assessment. And for what it's worth, it would have been extraordinary if they had. Subparagraph 3, the third subparagraph of the ground, is a criticism of Dr. Russell for his answer that it was urgent to refer and an emergency thereafter. And I need to take your lordships first in the light grey bundle to tab 10, page 244, which is where the exchange arises. just at little f, the judge is asking questions here of Dr. Russell. And just under G, she says, but just following up on that, if you want to get seen expeditiously as possible, contacting the hospital is a logic way of making a referral in the context of a certain emergency, which is, well, says Dr. Russell, what we have here. I think the terminology, says Dr. Russell, it was an urgent referral. I think it becomes an emergency, my lady, when the actual diagnosis is confirmed. And then that is said to be a basis on which the judge should have rejected Dr. Russell's evidence because it was inconsistent with the joint statement from the GPs, which we can find in Supplemental 1, which is the charcoal bundle at tab 22. And the answer which it's said to be inconsistent with is little b on page 243. The speed, urgency with which treatment should be sought and why. We agree that an urgent referral would be necessary, as this is the advice in NICE guidance. And all reasonably competent GPs would consider that CS is a potentially serious time-critical disorder that needs urgent referral for specialist assessment, diagnosis and management. Well, that seems to be entirely consistent with what Dr. Russell says. It's not dealing with the question of when treatment is done, it's talking about the referral, and that's what he said in his evidence. If one just goes forward to the next tab, one comes to the joint statement of the orthopaedic experts. And at paragraph 251, the answer to question 1b, to what extent is suspected acute CS a surgical emergency, the experts are agreed on this. Suspected cauda equina syndrome requires an urgent MRI scan to confirm cauda equina compression. Cauda equina compression demonstrated on MRI scan is a surgical emergency, which seems to be entirely consistent with what Dr. Russell said, and indeed entirely consistent with common sense. And what is said is this is a reason for which the judge should be criticised and reflects a sophistic distinction on the part of the defendants, which is untenable. Well, I've thought very hard about this, and I do not understand this point. I simply do not understand this point. That distinction is throughout the evidence, and the point is bad.
I suppose it only works with the wisdom of hindsight. You have a red flag, and on the basis of what we now know, the red flag did indicate what turned out to be a surgical emergency once you'd had the MRI scan. But that's the only way.
Well, that's the only way you could get emergency into the first bit.
But it only works on the basis of...
Because in answer to my Lord Justice Davis's questions about how many patients there are,
Why?
they can't. They need to be referred quickly. There's no question in this case that this man wasn't seen with speed, and it has to be done urgently. And that's. I mean, I can't do better than that. If it's a failure on my part, I apologise. But I just do not understand the criticism.
Next point.
Not considered belitho, ground 1C. So the judge has identified in her judgment the relevant, and I mentioned earlier, and you'll also have them in mind, but at paragraph 31 of her judgment, she identifies the Boland test, paragraph 31, And then she identifies Belitho at 33 and quotes that passage from Lord Brown Wilkinson, which, as we're here, I just invite the court to remind itself of, although I suspect pretty familiar. But Belitho is not a route by which, in every case where Bolam doesn't quite work, you substitute a lawyer's analysis to get to where you want to get. It's a very rare case where there's a body of opinion that can't withstand logical analysis.
Well, you get some situations like in Montgomery where Bolam is put to one side, effectively.
Well,
but that's a different
That's
situation.
completely different.
That's
if I
right.
may say so.
That relates to consent. It's quite
Yes, quite different.
Quite
and
different
that's
issue.
all about
Quite different issue.
Quite different issues.
There's nothing peculiar about the law in relation to medical negligence. It's exactly the same with the
course,
Hong Kong
professional
completion
negligence
case. The Hong Kong conveyancing, which everybody did in Hong Kong, was recognised by the Privy Council to be negligent because it involved risks which you didn't need to take. It's the same principle. Just because people do it doesn't mean it's right.
No. Yes, the only thing I would perhaps say, and I'm obviously straying out of comfort area, but when one approaches a non-medical professional negligence case, one has the sort of wider question of reasonable conduct. Whereas here, it's exactly the same test, but Bolam has given a specific way of assessing that reasonableness, which is then qualified further by Belitho. But of course, the test at the end of the day is taking reasonable care and discharging your duty of care to the relevant person. I mean, don't tell anyone, but actually it's all quite straightforward. This is where she sets Belitho out, and then she refers to the case of C and Cumbria. Now, she doesn't, when she comes to the section in which she deals with breach of duty on the part of the third defendant, paragraph 41, refer either to Bolam or to Belitho. Nor does she put a note at the end of that section saying, by the way, I haven't forgotten the tests I set out just before I addressed this element. And we say that the starting point is she's identified the tests, she had them in mind, she would have applied them. But the second point, and the more substantive point perhaps, is that it's obvious she did consider Belitho in this analysis. Because,
well, the word logical appears frequently in this passage.
Well, if it was just Bolam...
What she's saying, that what was done here withstands logical analysis.
Of course, she set out all the factors over all these pages. I mean, we've covered most of them in our discussions this morning, but she weighs up, in respect of each of the witnesses, what it is that they say, their counter-arguments and so forth, and then assesses Dr. Tanner's evidence, and then reaches that conclusion at 52. And of course, what my learned friend has to be able to persuade the court, if Belitho weren't in the judge's mind, is that the words, I've concluded that Dr. Swell's evidence is too inflexible when set against the evidence and publications, and that Dr. Russell's evidence accurately reflects a reasonable position, open brackets, which may or may not be logical. I mean, it doesn't work. She's concluded not, I have had two practices described to me, and I've decided to choose, in those circumstances, I can't find the defendant liable. She's gone way beyond that. She's considered reasonableness, and she's taken all the factors into account. And in my submission, that obviously your lordships will read again that analysis, and I'm not going to take you through it paragraph by paragraph. But all those factors that we've been talking about the guidance, the publications, the ability to have a scan at A&E, and all those factors are taken into account. And of course, the nub of the claimant's case on Belitho remains that this was illogical because it necessitated or introduced a delay. And we've explored that. But it's a false premise on which they seek to build that Belitho case. And it's not surprising that Dr. Swales and Dr. Russell have had different experiences. No one's doubting them, but sometimes it might be quicker at orthopaedics and sometimes it might be quicker at A&E. And we looked obviously at Professor Fairbank's evidence saying exactly the same. And one could add in as well, I'm not going to flag it, I'm just going to give the references, transcript bundle, so S2, tab 9, 150F, and then a little bit further on 160D to E, you get the evidence from Dr. Kirkby, the junior doctor in orthopaedics, who says, I'm looking after, I've forgotten now, is it 30 or 40 or 70 or 80 patients? I'm running around, I'm sort of on my own. My availability depends on what I'm doing at a particular time. And there are a number of other factors which are covered in the evidence, which might not be in the judgment, which if your lordships had tried this case, you would be able to take into account as well. And I just flag up by way of illustration. The first was that the flow of patients coming to A&E, which is my Lord Justice Davis's point. You needed to have some filtering system. There was a rationale to having a system whereby you filtered who was coming to orthopaedics. That was their practice at Watford. Secondly, Dr. Tanner was triaging a series of patients. He's a GP on the telephone with 20 to 30 people in a queue behind him. A factor that was raised during the course of the trial was that, discussed in the trial, was that he had to be mindful that he couldn't necessarily embark on a 20-minute phone call with orthopaedics and try and chase up when he's got 30 people waiting behind him who may have serious or more serious or equally serious conditions. Part of his process is getting people off to the next place as soon as possible. Now, the claimants say this raises very serious legal issues because this is a dilution of the duty owed to the claimant. Well, that's nonsense. This is taking into account in all the circumstances what it's reasonable to do. Just as in a hospital, a surgeon may not spend time doing certain investigations which his registrar could do because he could be better occupied doing surgery. So it's just looking at things in all the circumstances. And there is an oddity in this case because, of course, against my learned friend Mr. Hutton's clients, the claimant is going to say, or has said, in actual fact, you should have bumped all the others off the list and put me in first. Well, it's very difficult to reconcile that with the argument that once Dr. Tanner was triaging a number of patients, he could give each one as much time as he possibly could because he should ignore everyone else because his focus should be on... and then, my Lord, I'll just give you the reference. I've referred a couple of times to Dr. Swell's opinion that this was illogical, but then at tab 10 in the grey bundle, light grey, so S2, at page 224, C to E, he says it's outside his expertise to know whether or not A&E can arrange an MRI. So when one just raises a significant, perhaps we'll turn it up because it is perhaps important, given that that is the evidence which Dr. Tanner had to, in essence, respond to. Again, questions from the judge.
Which page?
224, behind tab 10. The judge says, under C, last sentence of that question, you accept that a doctor within A&E is a person with suitable training and experience. But I can't really comment on that, but as a GP, yes, I think. So that's the concession, I think. Yeah. I doubt they really were going, yeah. And that they could also arrange urgent tests such as an MRI scan. That's outside of my knowledge. Well, that's a very alarming basis on which...
But the point that could be made is that it was within Dr. Tanner's knowledge that WGH A&E could arrange MRI scans.
Yes.
And that was his evidence.
Yes. And my Lord, it works... Yeah, it works two ways.
Both ways, yes.
Because it might be right that in a case where you didn't know what the hospital had at all and you just sent off to the hospital and there was no MRI scanner and no orthopaedic department and you just sent them there, one might ask why you didn't find out what was there. And Dr. Swales' evidence is based on that lack of knowledge. But in circumstances where Dr. Tanner knew exactly what he was doing and did it on purpose, and we haven't gone back to his note of his discussion with Mr. Hewes, but you'll recall we saw it yesterday, in which he was saying, well, I need you to go to Watford because that's where there's an MRI scanner and an orthopaedic.
Yes? Next point?
At all. Then that concludes ground one. But I have to identify that within my learned friend's skeleton, there are two paragraphs which he identified yesterday. And if we could turn them up to the claimant skeleton, and it's paragraphs 6 and 7. And it's under a heading, a proper balancing exercise taking into account relevant factors. Now, I couldn't, during the course of yesterday's submissions or before, identify which ground of appeal against the third defendant this list of 8 different potshots at the judgment the claimant had been granted permission for, or how they went to the issues in the grounds of appeal. My learned friend invited the court to simply read those. One of the difficulties with that was we don't have any response to the response to those which are set out in the defendant's skeleton. And each of those, there's a response to it, and they vary from, you've just misquoted the wrong bit, to more substantive responses. But we don't have any idea whether any of those held good or not. And, my lord, I'd be delighted to work through each of them in my, but I rather suspect that this section, and then at the same time, Appendix 1, which I don't know whether your lordships have reached Appendix 1, but Appendix 1 is a list of a further run of supposed errors which the defendants have responded to just turn it up so I can identify it. Core bundle behind tab 10. Which 21, I think, particular bits are raised.
Well, the claimant treats without differentiation errors as being positive mistakes and also failure to make quotations in full. Well, of course, that's a different point.
Indeed, and we have responded to each of them. Every single one of those points is wrong, and every single one of the points in paragraph 6 and 7 are wrong, except for one which we conceded in error, which my Lord Justice Nugee identified yesterday, which was the time error, what the judge meant when she referred to 8 o'clock. And as it was being read, of course, it became apparent that, of course, she was talking about the time when the claimant would have got down to the hospital, not the time that the telephone call was made. So we conceded that as an error, and that indeed was our error.
It may not matter, but on the point that I raised, had the previous GP consultation involved going to just a hospital, or had it involved going to A&E? The judge recorded as A&E, and Mr. Booth said, no, that's not right, it was simply hospital.
So the evidence was from the claimant's own statement, and it did say to hospital. But, my lord, I would add this, because you can get to hospital as a sort of man in the street in 2 ways. You can be referred to a specific department, or you attend at A&E. You can't suddenly turn up to the cardiology department and say, I'd like some help. So when a doctor tells you to go to hospital,
well, anyway, but
so I think that's
strictly there was no specific evidence.
I don't think there was.
The previous doctor had said go to A&E.
No, I think that's.
But it may not be. There was the most important point.
I think I'll be corrected. I could hear muttering. I probably got it. So, my Lord, we of course invite you to read our responses, which is a joint effort between all the defendants, in the appendix, and also paragraphs 48 to 58 of the D3 skeleton. But we do slightly complain that it's not really appropriate to just have this sort of untethered range of allegations which we've responded to without knowing whether or not the court, for example, is supposed to assume that everything we've said is wrong. Is that the Claimant's case or not? My Lord, that brings me, if I may then, to ground 2 in factual causation. And the question, what would have happened if Dr. Tanner had telephoned orthopaedics at 6:30 or 6:15? Now, of course, by the time we get to this stage, it's no longer a live issue for the judge. It only arises if there's a breach of duty. But in any event, the judge did accept Mr. Langdon's evidence that it was likely that the orthopaedic team would have advised Dr. Tanner to send the claimant to A&E anyway. And for the appeal, again, it's only relevant if the court finds that Dr. Tanner was in breach of his duty and should have contacted the orthopaedic team. And your Lordship saw yesterday how the judge dealt with it, and it's fair to say it's identifying that she accepted Dr. Langdon's evidence. So the complaints are that the judge was wrong both in law and in fact for 3 reasons. And I'm not sure which are now pursued. But the first ground 2A, is that there was no evidence from the junior doctor who actually would have been the person who took the call. And that goes to what would have happened. Now, I wasn't sure whether that factual issue was still being disputed. But in very summary terms, we've seen it now. Mr. Langdon has given his evidence. He's not actually describing his own personal preference. He's talking about the policy at the hospital. So it carries quite a lot of weight to suggest that if there's a policy at the hospital to act in a certain way, one would expect the whole team to act in that way. So it's powerful evidence, and it's consistent with his witness statement, paragraph 12, which is, I won't take it's S1, tab 10, page 27. If it were someone else in the team who would have answered that call, and there's a suggestion they would have given a different answer. We never had a doctor who it would have been, but we did have a junior doctor, Dr. Kirby, and the claimant decided not to ask her what she would have done. So the first point seems to simply be a criticism of the judge for accepting what Dr. Langdon did. And that, well, it's evidence that goes to the point, it's relevant, and she was entitled to accept it. I don't think I can say very much more about it than that. The second is a procedural complaint with an implicit argument that this should have led the judge to reject Dr. Langdon's factual evidence. So there are 2 elements, as I understand it, to this. One, the claimant didn't have the relevant doctor who would actually have received the call provided by D1 so that the claimant could cross-examine them. And worse, the claimant himself believed that Dr. Kirby was the relevant doctor until the moment of trial. Now, these weren't raised by my learned friend in his oral submissions, so I'll try and deal with them quickly to flag up the responses. The first thing is, if this is an adverse inference situation, which I think is how it's being presented, it's quite important to remember I'm not D1, I'm D3. And I'm aware of any authority which indicates that if, and there's a large if here, it was appropriate to draw an adverse inference against a person because of some failing on their part, that can then be drawn against anyone else. There's no basis for that. Indeed, one might say, why can't I have an adverse inference then? I couldn't ask the doctor who would have answered the call, what would they have done? And they would have answered, oh, we'd have definitely done what Mr. Langdon tells us to do, which is to send to A&E. I mean, you can't have an adverse inference against the person you're not complaining about. That's the first thing. And the second thing is anyway an adverse inference would only be drawn in circumstances where there wasn't other evidence. It's got to be seen in the round, and here we've got the evidence of Mr. Langdon, which is more than sufficient for the judge to base her opinion. And third, we found it, insofar as this is relevant, and I'm not sure that it is, surprising that it was assumed by the claimant that Dr. Kirkby was the relevant doctor. And that was odd, we thought, for these reasons. First, it didn't say anywhere in Dr. Kirkby's witness statement when her hours of work were. It simply said that we simply knew that she was around at about 10 o'clock on the relevant morning. That was specifically noted, and I'll give you the reference, I'm not going to go to them, noted by Master Cook in a judgment he gave at an interim stage, that there was no information about the hours of Dr. Kirkby's work. That's at paragraph 68, and the reference is S1, tab 3, page 5. That judgment was in the context of an exchange in which the third defendant's then junior counsel had stated that it was clear that it would not have been Dr. Kirkby because of the changeover times at about 8 o'clock in the morning. In other words, if she was on the day shift, she wasn't going to be there at 6 o'clock on the previous night shift. That's just behind Master Cook's judgment, S1358. That is, unfortunately, the piece of paper that gave rise to our application and then the 105 pages in response to deal with it. There were, my lord, I see your lordship is, I'll turn these up.
No, I don't. We need to. We don't
Sure.
need to go, no.
I
I just reminded myself that the judge made a finding that Dr. Kirkby had started at 8 o'clock.
Well, it didn't have to make a finding. I mean, she came in the witness box and explained that's when her shift started.
And the judge
Yes.
found that,
Yes.
in fact.
Yeah.
Yeah.
But they're saying they're somehow, this has put them in a difficult position. The expert evidence from Mr. Cowie in this case, which reference S1 2220, paragraph 5.4, explains from an expert perspective that the norm is for changeover times at about 8 o'clock in the morning between night shift and day shift. And the claimant's own opening submissions identified that as a feature of the defendant's case. That the night-day shift handover was at 8 o'clock in the morning. So, my lords, I add to that, hesitatingly, that the observation that doctors change their shifts in hospitals at 8 o'clock in the morning is not something that would come to as a surprise to anyone who practices in this field. But I appreciate that claimant will say, I'm now giving evidence. But that caused surprise on our the last aspect on this adverse inference, and this isn't a point against Mr. Hutton, so I don't suppose he'll address it. The complaint is that D1 should have proffered this particular doctor. I am, of course, not privy to the correspondence between claimant and D1, but I have not seen any single request for the name of the doctor from the claimants, so that to allow the claimant to contact and call that person. And they could have made that request either in correspondence or in Part 18. They did serve a notice to admit in respect to whether Dr. Kirkby was on duty that day, which is a cost protection device. As we all know, if they have to prove that, they can then seek a specific cost order of that. But they didn't ask. So it's slightly odd now to come back and say that an adverse inference ought to be made against Dr. Tanner, who has nothing to do with any of this, in the face of evidence from Mr. Langdon. The second and third element of this ground of appeal is the failure to have adequate regard to the orthopaedic evidence and to consider a Belitho question. So having accepted Mr. Langdon factually, whether there should have been consideration of whether or not there should have been more than that, but a should. So the would and should, which was some exchanges yesterday from the court to Mr. Booth. My lords, it's fair to say...
Well, speak for myself, I can see the distinction in the present case from Belitho. In Belitho, it was the same defendant. But what do you say about the case of Wright?
Well,
Insofar as one can deduce what the ratio is,
Right.
if all three judges approached it on a different basis.
Yes. My lord, I'm going to tell
Are you going to come on to it?
Okay, if I can, in 20 seconds, but I want to say, because it's fair that I say, that at various stages, and including at the trial, the third defendant did not resist that as the appropriate approach that the judge had to take. So this wasn't an issue that was in dispute.
The third defendant did not resist what?
That in considering the hypothetical situation of Mr. Langdon, the judge had to consider both what he would have done and whether or not what he would have done was acceptable or not in terms of negligence.
But Dr. Tanner is not responsible for what Mr. Langdon does in terms of duty of care.
My lord, I understand, and we didn't resist that, and what I will say and indicate is the judge approached it on that basis. This issue that was raised yesterday was not an issue at trial, and it was, put it this way, it's an issue that in the context of this case, I mean, I endorse entirely a pragmatic approach and not getting into this legal issue when we, in our submission, say the facts were overwhelming. And when one comes to the law, and so I'm at your lordship's answer, it's very easy to distinguish this case from Belitho. The passage we saw yesterday talks about a defendant then relying on his subsequent negligence. And
that's the same person.
The same person, and you can see there's no difficulty with that as a question. If one then turns to Wright, and I think your lordship...
I don't recall having seen Wright before. Is it in the law reports?
I'm not sure, my lord. I think that's a... I think it's in some...
Is it in the law reports?
My lord, we believe it's in the personal injury and quantum reports, but not in
well, those are not my daily reading.
No.
Well, I have before me, my lord, our version is an original transcript, so one must assume...
I'd like to know how the law reporter got the head note up, I must admit.
Yes.
Strictly, if there is an official law report, that's what should be put before us. But so if you can remember, that's no matter. No, that's in the bundle of authority.
Yes, and I can't remember where you were invited to put it. I think at the very back.
We're right at the back.
Because it's at the very front of mine.
What's the PIQR reference, Mr. McLeish?
Sorry, that's just from memory. I think it might be there. I'm not quite sure.
Could you just after lunch, so we have it run it? Thank you. Now, so we've got Lord Newburger, we've got Lord Justice Elias dissenting, and Lady Justice Smith deciding on a different ground.
Yes. So, my lord, what I would obviously, I'm not inviting the court to decide this issue now, but I'll flag up what I think were your lordship's concerns and to refer to an extra section. So, at paragraph 31. In the Master of the Rolls, as he then was, his judgment, he talks about the whether or not the referring doctor could escape liability, and he does it almost entirely in terms of breaking the chain of causation. So this is a very different situation, in which we're very familiar with between joint tortfeasors, because the hospital in this case, although they weren't present...
And that's the way Lady Justice Smith...
Exactly. Although they weren't present there, and there was obviously much concern from Mr. Justice Mackay that the hospital weren't there, because they were the real baddies, if I can put it that way, weren't there. It was assumed that they were both tortfeasors, and therefore you're talking about quite a simple situation in which you've got two tortfeasors, and then you have to apportion between them. But if there is a complete difference between... the fault of the first in time and the second in time, that can break the chain of causation. And what one sees that in, the most common in the kind of clinical negligence world is where you have a road traffic accident and then you're off to hospital and the road traffic accident person can't get off. That's Barclay Bank Webb, and you can't get off unless there's an absolute break in the chain of causation. It's exactly the same in fire cases and all the other cases where you may have a break in the torch. And that was the passage that my learned friend took you to, and it seemed to be entirely different from where we were and easily distinguishable, culminating at 46 with a discrediting of the last opportunity doctrine, which got nothing to do with our situation. But, he says, at paragraph 56, there are several passages, several paragraphs, which do deal with belitho and the question of a hypothetical wrong, so the last sentence of 57. We were not referred to any case where it applied to a hypothetical wrong. And his conclusion then is at 61, which on the face of it would apply to our situation. So while I would merrily distinguish from the earlier section that my learned friend took me to, I would need more thought on paragraph 61. Sorry. Well, of course. Well, I think it's obiter, and if I were arguing, I'd be more careful. One of the reasons why I hesitate to say that is because one of the reasons why Lord Justice Elias dissents, one of the illustrations he gives, is, well, because if you arrived earlier, you might have got a different team of people. So that gives rise to the question, are we now shifting into Lord Hoffman's roulette wheel situation, or are we actually talking about a different factual scenario? So it's not an easy case, I would say. But at 61, there is a view from Lord Neuberger.
It's terribly,
terribly
dangerous to bring in the words loss of opportunity into this context. Normally, you should try and decide on the balance of probabilities.
And then
it creates so much difficulty.
Dame Janet Smith reverts to very much a causation analysis.
She viewed this as joint tortfeasors.
Exactly, and just where's there a break in the chain?
The doctor played his part in the overall result. Yes.
So I'm not just being loyal to those behind me. It seemed to be entirely appropriate when considering what points to take in this case and what points not to take in this case. This was probably one that didn't need to be taken.
So can you just, sorry, wait a minute, what was conceded below?
Well, I think I wouldn't, I don't think there was a formal concession. And in fact, we've looked overnight just to check that we're right about that, and I'll be correct if I'm wrong, but it was never dissented from that this was the appropriate way to deal with.
What was the appropriate way?
To ask, first of all, whether or not, on the hypothetical situation, what would have happened, and then a secondary question, what should have happened, which is how the judge approached it.
Did the judge do that? She clearly decided what would have happened.
Yes, well, we would say two things. So I suspect the issue that we're debating now, that it will arise again in a case in which it's absolutely critical, and no doubt it will be considered here and beyond as necessary. But we think, I hope, that it's not at the forefront of our case, this distinction. And
sorry to interrupt, but what, for example, are we to make of the last sentence of paragraph 45 of the judge's judgment, referring to Dr. Swales's evidence?
Sorry, I just...
It's the very last sentence.
Yes. Any medical reason must
he fairly conceded that. That's the line I'm focusing on.
Oh, I'm sorry, I'm looking at the wrong
paragraph 45 of the judge. That's all right.
I'm looking at another judge's judgment, which doesn't make sense.
Tab 16 in the bundle.
Yes, I've got it. Thank you. And I now know what your lordship is. Yes. So, my lord, from the negligence point of view of Dr. Tanner, there is no issue here that if they had said to him, sent to A&E, that he then had to query that, question that, or deal otherwise with that. I'm not sure that this is the same point as the factual causation point. Because
with respect, I think it is relevant because Dr. Swales has conceded that if the judge accepts the factual evidence that NGP would be informed to go, then NGP would have discharged his or her duty. Then the alleged failure to refer to session would not have affected the outcome.
Yes.
That seems to have been a concession in your favour.
yes, and I'm feeling uncomfortable about
if Mr. Langdon's evidence was accepted, and of course subject to the overall findings on liability.
But because what
may explain why the judge dealt with the point then rather shortly.
Yes, indeed. And my lord, I hope we're not, I don't think we are disagreeing, because we say that the judge did deal with this element in the way that the claimant wished her to deal with it, because, as we saw yesterday in questioning, she was querying whether or not that was an appropriate. So she obviously had the point in mind in her questioning. We know that that was how it was opened and presented and in closing by my learned friend, and it's clear that she considered carefully the evidence of Mr. Thorpe and Professor Fairbank. And in our submission, the accepting of Langdon evidence is easily understood to incorporating, I can accept it at one, on a factual level, and two, in response to the criticisms made by the claimant. She can accept that and rely on it, and hence she gets to paragraph 45. It's implicit that she didn't consider Mr. Langdon's evidence to be such that it should be rejected as unreasonable. And of course, that, in a sense, is overwhelmingly obvious in this particular case, because we're looking at the other end of the telescope. So having considered carefully whether it's appropriate for a GP to refer to orthopaedics, it would seem nigh on inconceivable that it would then be found to be inappropriate for an orthopaedic surgeon to refer to A&E. So given her findings against D3, it almost, it's not quite as night follows day, but it's very difficult to see how it could be right that the GP doesn't have to send to orthopaedics but can send to A&E, but an orthopaedic department is not allowed to send to A&E. So when seen in the case as a whole, it cannot be right. And the substance of it is...
Sorry, how much longer are you going to be?
Oh, I'm sorry.
No, but...
yes, sorry.
Are you very nearly at the end?
My lord, I'm very nearly at the end of this point, and then I was just going to say something briefly about timelines, but I probably would be in about 10 minutes.
Perhaps we'd better just...
sorry, I hadn't noticed.
I've been hoping to conclude your submissions by lunchtime, but
yes,
have another 5 or 10 minutes? No more?
No.
Right, well, in fact, I'm telling you, you can't be more than 10 minutes, all right?
Very well.
I'm telling you.
My lord, the reference for this authority is the Queen's Bench Reports 2013 at page 312.
Is it in the Queen's Bench Report?
It is, my lord, and the weekly reports. And,
oh dear, I really have stepped out. Is it discussed in any of the textbooks? Perhaps we don't need to make a huge deal of this, but...
My lord, I believe it is.
Well, the Clark and Lindsay is interesting, my lord, because it does refer to it, saying that the proposition, it says, first of all, the proposition that you're responsible for another hospital is established in Belitho, which is wrong. And then it says that this, apologies to my learned friends' chambers.
Well, anyway, could I have the report again?
It's 2013. Queen's Bench Reports, page 312, my lord.
312, because I want to see how the head note reads.
We'll obtain copies for your lordship.
Well, I'll try. And it's also in the, would have been in the weeklies as well, right?
It is, my lord.
13. Let's take our lunch break, shall we? 2:05, please.
Right.